This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Number 2, this meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of federal, state, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Great. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, province, county, city, or township agency present? I'm so glad I got that in there. This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Looks like we're all clear, and I'll state a short prayer. Oh, Holy Father, bless our meeting with eyes to see and ears to hear the messages and info being presented with an open and caring and compassionate heart for all our fellow brothers and sisters, as it may be done. Take it away, Glenn.
Okay, well, so I filed my lawsuit. I did it by mail because, they went and had all that hype about Real ID here last, like October or September. October. It was October, pretty sure. Or it was late September. It was maybe September. Anyways, they had all that hype about not being able to get into federal buildings without Real ID, and so I didn't even try and go down there. And I mailed it, and I told them to send me, a copy of one of them back. I sent an original and 3 copies, and so I called them up a couple days ago because I hadn't got it back, and made sure that it had been filed. It was actually filed the day after that they got it because I had tracking. And so that tells me that somebody was looking it over. Anyways, and they told me that I didn't have a self-addressed stamped envelope, or they asked me if I had one in there, and I says, no, I didn't. Should I have? And they said, yes, I needed to have a self-addressed stamped envelope. And so, but they said that it's down there, and so I can go down and pick it up. And I said, I did it by mail because I thought that they would need Real ID, and I said, I don't have Real ID. And they said, well, they basically said that that they don't require Real ID in that court. Okay, matter of fact, they don't require ID at all.
Nice. So nice.
Yeah. So I went
down. Did you
get
a name? There. You got a name of that person saying that?
I went down there yesterday, and and I didn't even. What I did is I left all my ID and everything in the car. And And I went in there and I was talking to the U.S. Marshals, and they said, normally you don't have to have ID, but they said that sometimes, depending on what's happening, you might. And so I said, okay, well, that's good to know. I guess that they're having some sort of a drill or something. Who knows? Anyways, I didn't even take ID at all. And I went to the clerk's office and took care of my business. And, they knew me down there anyways. I've been down there enough times. But no, I don't have to give them any ID at all. And so that was kind of nice. Anyways, I filed it, and this was in the mail. I went and got my mail today. That was yesterday when I went to I picked up my copies of the lawsuit. Today, this was in the mail. And let me see if I can make it a little bigger.
Any signage in the courthouse?
Sorry?
Like, was there any signage requiring all that?
No, there was no signage or anything. There was none of that. Okay, so this is document number 3. This is the one that I want to talk about today. It's case number 425 CV 1299, which is 4 means it's in the Fort Worth division, okay, of the Northern District of Texas. 4 means Fort Worth division. This is filing procedures. After you've filed your complaint, unless you're excused for cause or the presiding judge directs otherwise, you must register for the electronic case files. Okay, electronic filing. And so I already dealt with this. I never did electronic filing in the past. I haven't done it at any time. And this is how I deal with it. And so that's what I'm going to do right now, is show you how I deal with it. So this is the document. I printed it off, but I actually made some changes, so I'm going to have to redo it. But this is actually short and sweet. It's like 2 pages. So I'm just checking and making sure that it's coming through good on YouTube. And it is. Good. By the way, as a side note, I have been asking YouTube to review. They took about 20 of my videos down at various times. And so I've been asking them to review them. And they have put all of them back up except for a couple. And so, and one of them, I actually edited out what they were having a problem with. And I'll look at the other ones and see if there's something I can edit out nice and short. But the bottom line is, though, is that they put my videos back up, and it's been helping my monetization too. So anyways, that's a side note. This is a notice of objection to the District of Columbia electronic filing. So the demandant will gladly do electronic filing when A, this court provides her statutory and delegated authority to compel the demandant to do electronic filing, and B, this court provides an order signed by a judge with the court seal on it that the demandant apply for a social security number and then a bank account and then get a debit card for their electronic filing, all of which falls under the Pope's Roman canon law, in case you didn't know, okay? The negotiable instrument law is part of Roman law. And C, this court provides an Article 4 an amendment warrant signed by a judge acting in his official capacity with the court seal. I should change that. There we go. with a court seal that orders the demandant to disclose all or part of the Social Security number, the debit card number, and further disclose anything else at the electronic filing system that is required. Calling out specifically what has to be disclosed as required by Article 4 and Amendment for their electronic filing. And that's it. Signed and sealed in red ink on the land under penalties of perjury without the Pope's United States. And then the mailing address is without the Pope's United States. And there might be some more things. I don't have to file this till Monday now because everything's closed till Monday. So who knows? Maybe I'll come up with some more stuff. Matter of fact, I was actually thinking about that.
You used that when they took your YouTube channel down and wanted you to comply with something along those lines there too, correct?
Actually, with YouTube, I told them they're engaged in multiple felonies, and I told them that their board of directors and executive officers are personally liable in their private capacity, and I was going to sue their butt off, and that I've been to the U.S. Supreme Court 5 times, and they were next. And then all of a sudden, my channel magically came back up.
Yeah, you got to drop that in your room for us.
This document?
Mm-hmm.
Sure. Yeah, no problem.
Awesome. Thank you.
Yep. Yeah. Yeah, I've been tweaking it here. By the time I'm done, though, I don't know if they want a name. I think they do, though, and an address. So where's the order? They provide a search warrant requiring that I disclose an address and a name and a debit card number and a Social Security number, all or part. Usually they want like the last 4 of a Social Security number. And all of this up here is Roman law. Anyways, so after I filed this last time, it was like crickets. Never heard another word about it. Okay, so that's this one. Now, why don't we go through my war crimes complaint? This is filed copy. This is what actually got filed. And actually, I got to tell you, I'm going to file an amended one. Sorry?
What do you need to add?
Oh, there's going to be some people added. I got to add in some stuff about forgery. I got to add in that I believe that they have engaged in aggravated identity theft, in accounting fraud, in concealment, in securities fraud, in tax evasion, in embezzlement, and in forgery. And they forged my name onto 3 bonds: a bid bond, performance bond, and a payment bond, and on a 1099-A. And I intend, what I'll do is I'll get a forensic accountant to research it and provide proof that that's what happened. And so they're going to be fucked. Matter of fact, what's going to happen, I'll tell you right now, is when I put that shit in there, they're going to want to settle this matter really bad, because what will happen is if it comes out if there's proof that that's what happened, then every case that the Tarrant County District Attorney has prosecuted since he took office will have to be vacated, and all those people kicked out of prison, and all sorts of shit's going to go down. And so they're going to want to settle it. So that's okay. I'll settle it. Not a problem. Anyways, so yeah, I'm definitely going to do. I'm entitled to one amended complaint, and so I got to make it good when I make it, because after that I might not get another one. Anyways, so this is. So let me look. Yep, it's coming through good on YouTube. Okay, good. So this is the file stamped one. So I have, the whole page, basically, of respondents. Demandant herein hereby affirm the following facts. The demandant is competent to state the facts and evidence herein, and if called to testify, shall so state. The demandant makes this affidavit because the military police are peddling lies and disinformation for their communist agenda to create a civil war for their communist handlers, terrorizing the people of the Republic of Texas because they intend to create the scenario so they can murder the demandant and create business for themselves because they hate anybody who thinks they have rights. The demandant has no first-hand knowledge of a date of birth, but can say the demandant remembers finishing high school in 1975, over 50 years ago. Therefore, the demandant is well past the age of majority. The demandant's mother was into genealogy and has done extensive research on ancestry to the point that she discovered that Will Livingston ratified the Constitution for New Jersey was the demandant's fourth-grade uncle, which means the demandant is posterity as found in the preamble. And the demandant is entitled to right of blood, and right of blood cannot be destroyed by any civil law because all the laws of Congress after 1871 and all the laws of Texas after the Civil War are civil laws. And that's Bouvier's Law Dictionary, 1856 edition, volume 2, page 132. Right of blood and kindred cannot be destroyed by any civil law. And these military police are operating under a power which is derived from the demandant as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. And is further elaborated by the U.S. Supreme Court, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. This court has jurisdiction because it's involving war crimes against the demandant and the people of the Republic of Texas, and because of the Republic of Texas. This court has jurisdiction because the wrongdoers named herein are depriving the demandant and the people of the Republic of Texas of U.S. constitutionally federally protected rights, including but not limited to the right to pursue happiness, the right to get compensation for labor, the right to engage in constitutionally protected activities like conduct a common law court, the right to seek a redress of grievances, and the right to exhaust administrative remedies, and the right to due process of law, and the right to life, liberty, and the pursuit of happiness, as found in Organic Law, the Declaration of Independence, 1776. The wrongdoers in this case are operating under color of law to violate the demandant's right to self-determination to be a Texas national, as well as the right of the people of the Republic of Texas to self-determination to be Texas nationals, guaranteed by the International Covenant on Civil and Political Rights, as well as the 1933 Montevideo Convention on the Rights and Duties of States, both of which have been acceded to as treaty law by the U.S. Senate. Excuse me. The wrongdoers are setting up the demandant to murder him so they can make work for themselves, justify their jobs, sedge some innocent blood for their bar member handlers. Since 2007, when the demandant became involved with the Republic of Texas and was exercising his right to seek a redress of grievances, exhausted administrative remedies, and exercised his right to self-determination as a Texas national, and the wrongdoers have engaged in repeated, systematic, and continuous war crimes against the demandant and the people of the Republic of Texas, only some of which is evidenced herein. The demandant will show the court that the state of Texas is a fictitious overlay over the Republic of Texas. The Republic of Texas, recognized by Andrew Jackson, still exists. In the early 1990s, some people of Texas discovered this and brought the Republic of Texas out of abeyance by forming a provisional government of the Republic of Texas and started holding elections for the Republic of Texas and have been peacefully holding elections ever since. The wrongdoers have engaged in repeated, systematic, and continuous violations of the demandant's common law rights under color of law with slander, defamation, assaults, false arrests, kidnappings, false imprisonments since 2007 in the free exercise of his rights to engage in U.S. constitutionally protected activity under color of law. The wrongdoers are taking reprisals against the demandant and the people of the Republic of Texas for our religious beliefs to subject us to their satanic religious ceremony with their fraud, deception, necromancy, and idolatry. The wrongdoers have engaged in a malicious prosecution. See Thomas versus Clark, decided April 4th. So it was dismissed, which means it was a malicious prosecution. Unlawfully arrested the demandant with a fake warrant, kidnapped the demandant, falsely imprisoned the demandant as part of their war crimes agenda and retaliation against anyone who exercises their right to self-determination as a Texas national. These wrongdoers named herein and others are creating terrorists to make business for themselves and shed some innocent blood for their handlers. All the wrongdoers named herein are being sued in their private capacity. An officer who acts in violation of the Constitution ceases to represent the government. No state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. The constitutional theory is that we, the people, are the sovereigns. The state and federal officials only are agents. If government officials attempt to enforce an unconstitutional law, sovereign immunity does not prevent people whom the law harms from suing those officials in their individual capacity and their injunctive relief. This is because they're not acting on behalf of the state in this situation. It has been settled that the 11th Amendment provides no shield for a state official confronted by a claim that he deprived of another of a federal right under color of state law. It is well established that the military police officers like Casey Brashear, Andrea Brandt, Marshall Thomas, Captain M. Lugo, Bobby LaPena are screened for low intelligence and a propensity for aggressive behavior. See Jordan versus City of New London, U.S. Court of Appeals for the Second Circuit, number 99-9188, and are essentially hired thugs, as evidenced herein. These military police have uniforms, rank structures, and police vehicles with colors with flashing lights that are designed to be threatening and intimidating, designed to instill fear into people, which is just another reason of many that they are the terrorists and are deliberately calculating and maliciously terrorizing the people of the Republic of Texas. Bar members Leah Simonton, Phil Sorrells, Kelly Higgins, Daniel Cicada, Stephen Jones, Hal R. Ray, Reed O'Connor, and Chris Johnson are some of those handling their military police in support of their military dictatorship and are officers of the court and deemed to know the law. These military police and their bar member handlers have ceased to represent the government. I read those already. The Secretary of State is named because the Republic of Texas was recognized and still exists, and we think it would be good for everyone to enter into negotiations for a treaty of peace to bring an end to that very difficult war between the states, at least as far as Texas is concerned. And the defendant tried to get the president of the Republic of Texas to send the president of the United States a proposal, but after Brashear's malicious prosecution and previous malicious prosecutions with Susie Kamak, as described herein, they're all hiding for fear of being maliciously attacked with more war crimes. The Republic of Texas recognition. President Andrew Jackson officially recognized the Republic of Texas on March 3rd, 1837, which was also recognized by France December 25th, 1839, and other nations, including Belgium and the United Kingdom, and the demandant has visited the former embassy of the Republic of Texas in Paris, France, that is now being used as a hotel. The fact that the Republic of Texas existed is beyond dispute, and there's no definition about how many people are required to constitute a nation or state, and this is taken from the Law of Nations by Vattel. A nation or state, as has been said at the beginning of this work, a body politic or society of men united together for the purpose of promoting their mutual safety and advantage by their combined strength. From the very design that induces a number of men to form a society which has its common interests, which is to act in concert, it is necessary that there should be established a public authority to order and direct what is to be done by each in relation to the end of the association. This political authority is the sovereignty, and he or they who are invested with it are the sovereign. And that's taken from the Law of Nations by Vattel, Book 1, Chapter 1, Section 1 of the State and of Sovereignty. In the year 1845, the state of Texas joined the Confederacy and Union under the Articles of Confederation and Perpetual Union, 1781, as evidenced by the Act of Congress at 9 Stat 1. It still exists as evidenced by HJR 1, dated 29 December 1845. The territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the State of Texas, and on an equal footing with the original states in all respects whatever, with the Republican form of government as found in the Act of Congress, December 29, 1845. And this is in the preamble of the Act at 9 Stat 1, be it enacted by the Senate and House of Representatives and Congress assembled, that all the laws of the United States are hereby declared to extend to and over and have full force and effect within the state of Texas, admitted at the present session of Congress into the Confederacy and Union of the United States. So they into the Confederacy and Union of the United States. And so the Confederacy is talking about the Articles of Confederation. And whereas the Congress of the United States, by joint resolution approved March 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state. So they're erecting a state within a state to be called the State of Texas with the Republican form of government. And it says here at the end, it says, and admitted into the Union on an equal footing with the original states in all respects whatever. That's talking about the Articles of Confederation. Because normally when one sovereign nation joins another sovereign nation, a treaty of annexation is done. A proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted but was shelved. The state of Texas was created under the Articles of Confederation and Perpetual Union, 1781, under Article 9. Article 9 says, Canada ceding to this confederation and joining in the measures of the United States shall be admitted into and entitled to all the advantages of this union. But no other colony shall be admitted into the same unless such admission be agreed to by 9 states. Which means a House joint resolution is all that was used. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas. The territory properly included within and rightfully belonging to the Republic of Texas, which means the Republic of Texas was not replaced with the state of Texas, and the Republic of Texas still existed in abeyance or dormancy. It seems that to the demandant that for the state of Texas to join the Confederacy under the Articles of Confederation, 1781, with the House Joint Resolution is probably perfectly fine. But the current Constitution was in place in 1845, and Article 4, Section 3, Clause 1 requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what happened. Whatever happened in 1845 is probably moot because the state of Texas is currently under a military occupation as described herein, and none of it affected the Republic of Texas. In the year 1861, the southern states walked out of Congress, and Congress ceased to have a quorum to conduct business and could not conduct business. On 15 April 1861, Lincoln ordered Congress to reconvene under executive authority with Executive Order Number 1 at 12 Stat 1258, and they've been operating under executive authority ever since. The southern states have walked out of Congress, became the Confederate States of America, and the war between the states was started, which eventually ended with an armistice, a ceasefire only. All of those people are now dead, and there's never been a treaty of peace. The state of Texas was one of the Confederate States of America, and a technical state of war still exists between the United States and the Confederate States of America because there's been no treaty of peace. But there was an armistice, which is a ceasefire only. In the year 1863, Lincoln asked Harvard Law professor Francis Lieber to write the law of war for the U.S. Army, which became known as the Lieber Code, but is actually designated General Orders 100, all of which is now included in the United States Law of War Manual, which is now a book about 4 inches thick and is part of international law or the law of nations. The current state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, the Lieber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. Martial law continues to this day under Article 2, General Orders 100, Libra Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war, when the occupation of the place or territory continues beyond the conclusion of peace as one of the conditions of the same. Because there has been no special proclamations by the Commander-in-Chief, President of the United States, and there is no Treaty of Peace to this date. In the year 1871, while operating under executive authority, Congress authorized a municipal corporation to operate in the District of Columbia at 16 Stat 419, which is talked about in the dissenting opinion of Downs versus Bidwell, as the second national government that is maintained by Congress outside and independently of that instrument, which is the Constitution, is what they're talking about. And this is the actual site. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. That the military police are conspiring together with their bar member handlers to work for. An officer who acts in violation of the Constitution ceases to represent the government. In violation of their oaths to support and defend the supreme law of the land, Article 6, Clause 2. This Constitution and the laws of the United States, which shall be made pursuant thereto, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. The 1933 Montevideo Convention on the Rights and Duties of States was ratified by the United States as a treaty entering into force December 6, 1934, which requires that recognition is irrevocable in Article 6, and under Article 8, no state has the right to interfere in the internal or external affairs of another state. And further evidence of the war crimes being engaged in by these military police in conspiracy with their bar member handlers to threaten, coerce, injure, intimidate the people of the Republic of Texas in the free exercise of our rights to engage in U.S. constitutionally protected activities of common law courts and petition the military government for redress of grievances in support of our right to self-determination and our right to determine our own political status as Texas nationals, violating the International Covenant on Civil and Political Rights as a treaty entering into force September 8, 1992. State of Texas military dictatorship. Under HJR 1, dated 29 December 1845 at 9 Stat 108, the state of Texas was required to have a Republican form of government. And it's impossible for a military government operating under martial law to be a Republican form of government, because the military government is a dictatorship, as evidenced by Article 3 of General Orders 100, Libra Code. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and the domestic administration and government of the occupied place and territory, and the substitution of military rule and force for the same, as well as in the dictation of general laws as far as military necessity requires this suspension, substitution, or dictation, as in dictatorship, folks. That's what it is, a dictatorship. And because the Republican form of government requires law of the land, natural law, and common law, and political power to be in the hands of we the people, and a symbolic military government called a democracy with all the state of Texas employees including all the wrongdoers named him being federal personnel, as required by the Roman Civil Codes 5 U.S.C. 552 AA 13, which is anyone with a Social Security number. The term federal personnel means officer employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. For their 1871 municipal corporation at 16 Stat 419, Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action whichever particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. That exists today is the second national government talked about in the dissenting opinion of Downs versus Bidwell that is maintained by Congress outside and independently of that instrument, the Constitution. Is a military dictatorship, and the United States has failed to provide a Republican form of government as required by Article 4, Section 4. The United States shall guarantee to every state in this union a Republican form of government, except that the Republic of Texas is that Republican form of government, but it is being maliciously attacked. And that's C. Thompson versus Clark. It basically says that if they dismiss a case, then it's malicious. Attacked by screen for low intelligence military police and conspiracy with their bar member handlers. After the war between the states and its armistice, many years have passed, and all those involved in both sides are now dead. And in the early 1990s, some of the people of Texas, after reviewing the act of Congress at 9 Stat 1 and the resolutions HJR 8, March 5th, 1845, 5 Stat 797, HGR 1, 29 December 1845 at 9 Stat 108 of the U.S. Congress and other historical evidence discovered that the Republic of Texas was in abeyance, which is dormancy, as an entirely different entity from the state of Texas, and the Texas territory is properly included within and rightfully belonging to the Republic of Texas, and brought the Republic of Texas out of abeyance and organized the provisional government of the Republic of Texas and peacefully held elections, and have been peacefully holding elections ever since to peacefully provide common law remedies for the people of Texas. The Republic of Texas is a foreign government under 18 U.S.C. Section 11, irrespective of recognition, because the first thing state actors say to us is, we do not recognizing you, speaking of the Republic of Texas, even though it's the same Republic of Texas that was recognized by President Andrew Jackson March 3rd, 1837, which is also recognized by France December 25th, 1839, and other nations, including Belgium and the United Kingdom. Recognition is unconditional and irrevocable under Article 6 of the 1933 Montevideo Convention on the Rights and Duties of States that was acceded to by the U.S. Senate as a treaty and entered into force December 26, 1934 at 49 Stat 3097. The Republic of Texas is a group of men and women on the territory properly included within and rightfully belonging to the Republic of Texas, trying to peacefully bring common law remedies to the people of Texas as a Republican form of government, because the state of Texas is a military government operating exclusively under martial law as a military dictatorship and can never be a Republican form of government. Treaty of Peace. Even though the demandant has resigned as a senator because of the threats, terrorism, intimidation, coercion, injuries by the wrongdoers named herein, the demandant can say with some authority after being involved with the Republic of Texas government for almost 20 years that the people of the Republic of Texas would very much like to enter into a treaty of peace in the United States to bring to an end to the war between the states as far as Texas is concerned. We believe it would be good for everybody, and maybe other states formerly part of the Confederate States of America would like to do the same. It would be very good to bring that dark chapter of our history to a final conclusion. Case dismissed for lack of jurisdiction in the year 1995. The Supreme Court of Texas dismissed a case involving the people of the Republic of Texas for lack of jurisdiction. Case 95-1002, styled In Re, the people of the Republic of Texas, by and through Richard L. McLaren. Their legal diplomatic representative is acting ambassador, consul general, and legal affairs officer for the Territorial Land District, evidencing that they know they have no authority over the people of the Republic of Texas. Right to self-determination and political status. The U.S. Congress and the President of the United States have acceded to the International Covenant on Civil and Political Rights, 9 June 1992, and is now supreme law of the land as a treaty under Article 6, Clause 2. And we, the people of the Republic of Texas, have the right to self-determination and the right to determine our own political status as Texas nationals. Therefore, we are engaging in U.S. constitutionally protected activity, and the military police are conspiring together with their bar member handlers to threaten, coerce, injure, and intimidate and injure we, the people of the Republic of Texas, in the free exercise of our right to self-determination to determine our own political status as Texas nationals for our Republican form of government guaranteed under Article 4, Section 4, since the Pope's owned and operated United States has failed to do so. The demandant has never in his life breached the peace, but the military police breach the peace on a routine basis with their unlawful arrests, false imprisonments, kidnappings, as described herein, and they slandered and defamed the demandant repeatedly in countless ways, as described herein, and demonstrated they want the demandant, anyone who thinks they have common law rights, dead, because they're doing exactly what Lieutenant General Michael Flynn, U.S. Army retired, says the U.S. Army does to an enemy in his book, The Citizen's Guide to Fifth Generation Warfare, Session 1 and Section 3-3. First, they polarize the enemy. Second, they tribalize the enemy. Third, they dehumanize the enemy. And finally, fourth, they kill the enemy, which is their objective for the demandant. They intend to murder the demandant. They've slandered the demandant, defamed the demandant, dehumanized the demandant, calling him a sovereign citizen terrorist for their bar member handlers, to the point his own sons and daughters do not talk to the demandant for fear of being slandered and defamed themselves. Another war crime for these military police, the fucking pigs, and their bar member handlers have demonstrated that they intend to continue the slander and defamation to create terrorists so they can shed some innocent blood for their handlers and justify the demandant's murder, and the demandant turns up dead for their handlers. The military police and their bar member handlers claim that people they label as sovereign citizens do not think the law applies to them, and that is entirely false. And evidence of their low intelligence threats, lies, terrorism, and calumny that they are peddling to generate business for themselves as part of their agenda to polarize and tribalize and dehumanize the demandant and the people of the Republic of Texas in preparation for the fourth and final step, murder. The truth of the matter is that the Constitution under Article 6, Clause 2 is the supreme law of the land in America, and the phrase law of the land is talking about common law. And if you want to read that, that's actually taken from Book 16, American Jurisprudence, 2nd edition, Constitutional Law, Section 543. And common law and law of the land has always been here long before the government was here, and that's found in Hale versus Hinkle. Here's rights or such as existed by the law of the land, long antecedent to the organization of the state. That's long before. And was here long before the government was, and the military government is required to step aside when we the people step forward. Ex parte Milligan and common law. Common law is everywhere above the high water mark and after the first bridge on any navigable river, except for the District of Columbia, Article 1, Section 8, Clauses 17 and 18, and any federal enclaves, as affirmed by Section 14 of the Organic Law, the Northwest Ordinance, that was passed just 3 months prior to the U.S. Constitution being ratified by the demandant's fourth great-uncle, among others, as well as affirmed by the Judiciary Act of 1789 and the Judicial Code of 1911. All of which is evidence that the military police and their bar member handlers intend to perjure their oaths to the supreme law of the land because they're busy working for the 1871 Municipal Corporation at 12 Stat 419 under Roman canon law, which is the second national government maintained by Congress outside and independently of that instrument, talked about by Justice Marshall Harlan in the dissenting opinion of Downs versus Bidwell. Using the Commerce Clause to bring the District of Columbia dictatorship outside a maximum of 10 miles square. The truth of the matter is that a common law proper name is never spelt in all block capital letters. Therefore, the name GlennWinningham Fern is a derogation of common law and a fiction of law, as described herein, and a minor estate at 31 CFR 363.6. And the truth of the matter is that in the year 1213, Pope Innocent III coerced King John into giving the Pope his kingdoms. And that's not long after this by general excommunication of the king and people for several years because they would not suffer an archbishop to be imposed on them. King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. And that's Volume 2, Tomlin's Law Dictionary, Volume 2, under the definition of Pope. And rending him back with the concessions to the Pope, 1213. We will establish the perpetual obligations and concessions to establish the proper special revenues or aforesaid kingdoms for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 namely for the kingdom of England, 300 for the kingdom of Ireland. And that's concessions of England to the Pope, 1213. The truth of the matter is that the minor estate sesticae usufruct was created by the Sesticae V Act of 1666 by the Pope's owned and operated Crown of the United Kingdom. And this is, yet still it was found difficult to set bounds to ecclesiastical ingenuity. That means the Pope, folks. For when they were driven out of all their former holes, they devised a new method of conveyance, by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses. That's the Vatican. Thus distinguishing between the possession and the use, and the receiving the actual profits, while the season of the land remained in the nominal fief. It was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to a sesticate use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Use is short for usufruct. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And brought into the United States with the Code of Law for the District of Columbia in 1901 at Chapter 854, an act to establish a code of law for the District of Columbia, the legal estate to be the sesticate use. And 1617 at 31 Stat 1432, and now codified at 31 CFR 363.6, because of the necromancy sesticate use, which is usufruct, people are presumed dead. At Chapter 3, absence of 7 years, where it says presumption of death. He shall be presumed to be dead in any case where his death shall come into question unless proof be made that he was alive, which is now called the minor estate, is an entity, because an entity includes the estate of a living person, such as an incompetent or a minor. And this is 31 CFR 363.6. Entity means the owner of a treasury direct account that's not an individual. Sole proprietorship, partnership, corporation, limited liability company, professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who's failed to take control of the securities in their treasury direct account. Minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account, which is a fiction of law, which falls under Roman canon law, which was invented by the Roman praetors under the pretense of doing equity, and owe their origins to the legislative usurpations of the bench. And that's found in Bouvier's Law Dictionary, 1856 edition, volume 1, page 520. And fictions of law are necromancy and satanic. You know, all you Satanists out there, you people that are calling yourself Christians, you're really Satanists because you're letting this stuff happen. There shall not be found among you anyone that maketh a son or his daughter pass through the fire, or that useth divination, or observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, because these abominations the Lord thy God doth drive them out from before thee. And that's Deuteronomy 18:10-12. And put you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by session of particular state and the acceptance of Congress become the seat of government of the United States. That's Article 1, Section 8, Clause 17. And everything in the Code of Federal Regulations, including the minor estate, is government property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property of the United States, property belonging to the United States. And the demandant may have an interest in the minor estate, but the demandant wants nothing to do with it because it's created by fraud and deception, and it's necromancy and satanic as described herein. And it's truth of the matter, it's a badge of slavery because it is property belonging to the United States. because a slave is a thing that is owned as property, because the military police are using the minor estate in the Commerce Clause, Article 1, Section 8, Clause 3, to bring the District of Columbia plenary jurisdiction outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17, because their minor estate, 31 CFR 363.6, is a type of a trust. And a trust is property and a thing and has no rights and falls under Roman canon law. And the military police are all U.S. citizens of the District of Columbia as required by their Roman civil codes for their 1871 municipal corporation. Because there's two national governments, and they intend to make sure the demandant submits to it or the demandant will turn up dead. And then they get to pillage the fake money in the Treasury Direct account under GlennWinningham Fern in all black capital letters, under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2nd of October 1973, and the demandant is not suicidal, but if the demandant does turn up dead, this is deathbed testimony, or the demandant will be subjected to the District of Columbia military prisons, which is exactly what has already happened, as described herein, that there are warrants that fail to be authentic in their District of Columbia Roman law so-called courts. Therefore, whether they enslave the demandant or kill the demandant resisting their slavery, either way, it's a win-win-win scenario for their military police and their handlers. Don't get me going.
Yeah, don't tell them how you really feel or anything.
Yeah, so anyways, just going to look at YouTube here. Okay. And a Telegram. So I don't know. Do you want to keep going through this? It is, well, with the attachments, it's 190 pages, but we won't go through all the attachments. I mean, we can go through those quickly if you want. It won't take long. We certainly don't have to read them. A lot of them, it's just an image, and you can see the image without any trouble. Some of them I don't want to go through because there's personal information in them.
Just share what you've made changes on, because we went through a bit of it over the past 2 weeks. So
we did.
Yeah, we're good. But no, that's pretty much true for all of us, right?
Right.
Yeah. Hi. Could you post some of the verbiage on the wall, please, of this? Because I need to remember these codes, and it's nice to hear you read them out. The more repetition my brain hears, the more I'm more apt to remember.
Well, I can post the Word file from the lawsuit. Would that help?
Yes, please. Thank you.
Yeah, no problem. Maybe I'll continue with where I was at. I'm just trying to look and see where, because I thinned it down, number one, and also Randy Kelton, wanted me to, make some changes, which some of the stuff I've already shown you, the changes that he wanted me to make. And there's other changes he actually wants me to make, which is what I was going to incorporate in the second one. This one's actually been filed. I think some of this stuff, well, I'll just breeze through it. I'm just going to breeze through it because, so I learned about the Republic of Texas in 2004, and I got elected to Congress in 2007. I was Speaker of the House of Representatives. 2009, I got a contract in White Plains, New York, and went to White Plains, resigned from the Congress at least. And while I was in New York, they asked me to be in charge of the affairs. They wanted me to approach the Russian Federation about Treaty of Peace and Recognition. So they sent me a charge of the affairs commission, but I never did. They never did give me the green light to go ahead and go to the Russian embassy, so it never did happen. And then I was sending notice and demands. I've sent out literally thousands of notice and demands. Spent a hell of a pile of money doing it. Anyways, I sent one to the Montana director of the Highway Patrol, and he went and sent it to the state, the Texas DPS, and they issued an intelligence bulletin against me saying I'm armed and dangerous. And so then I started getting harassed all the time. I started getting harassed at airports, border crossings for extra screening. 2012, I went back to Texas. 2013, I was unlawfully arrested, assaulted, kidnapped, while in prison, physically dragged into a U.S. Border Patrol office on I-10, about 10 miles west of Sierra Blanca, Texas, for about a half an hour before they told me I could leave. I filed a lawsuit. This is the case number, and Sam R. Cummings called it frivolous. That was 13th of August, 2013. And so that's in the records of the court. The demand filed a lawsuit in Texas courts, and Janet Napolitano refused to accept service, and there was no address to accept service on the border thugs, and it was eventually dismissed for failure to prosecute. In 2013, the demand missed a flight from Calgary because of customs delays, and there was a customs official he was a really nice guy actually, and he suggested I do a FOIA request with the U.S. Marshals, so I did. And 500 pages of my notice and demands came back, was redacted, so that you couldn't tell who was sent to. But and
Was that guy Canadian? Was that a Canadian border thug?
Well, it was a U.S. Customs official in Canada. If you go through U.S. Customs, it'll be in Canada. They don't make you go through customs in the U.S. If you're flying from Canada. It's all done in Canada. I don't know why they do it. It's just Canada as far as I know. I think maybe it's because Canada is part of the United States. Who knows, eh? Certainly can be under the Articles of Confederation. Anyways, there was also an intelligence bulletin that was in there. Anyways, then I was arrested at the border with Canada for smuggling because they went and had a lookout notice saying I'm armed and dangerous, sovereign citizen, and that kind of stuff, because Texas was sharing with their Five Eyes Alliance buddies. And so they did a search of my 34-foot travel trailer and found a can of pepper spray and a high-capacity magazine. And in communist Canada, anything over 5 rounds is high capacity. Anyways, they held me in their torture chamber for over 24 hours. That was like 40 degrees. You could see your breath. It was cold. All I had was a short sleeve shirt. They took my coat away, and it was a short sleeve shirt. I was freezing my butt off in there. It's a torture chamber. In early 2014, I was at the U.S. consulate in Calgary to get a passport, and they decided to take a lunch break. And after business suspension finished, I went downstairs, and the military police were waiting and arrested me, and because of that, the smuggling issue. And I wound up spending 82 days in jail for their fake smuggling charges, and part of their retaliation for having the audacity to seek redress of grievances, exhausting administrative remedies, and self-determined Texas national status. The kangaroo court had ordered the minor estate to undergo a mental evaluation like the communists do to their political dissidents by putting them into mental institutions to perform forced medical experiments on them, just like they're doing to Bonnie Strait right now. So after being released from their jail, the demand immediately left the country and has not been back. On February 4th, 2015, Valentine's Day, the Republic of Texas Congress meeting in Bryan, Texas, was raided by the Kerr County Sheriff's Department, the weaponized Federal Bureau of Investigation, the U.S. Marshals, the Bryan Police, and the Texas State Police, because Susie Kamak, a member of the House of Representatives, had convened a common law court over the theft of her home, and they were calling it a simulated legal process. They seized the demandant's laptop, computer, and carrying case, and the demandant has not received any of it back to this day. They're a bunch of thieves. Don't get me going. You're going to get me going. On the 21st of July, 2014, the demandants for a power plant license, student pilot certificate were suspended because of the TSA's initial determination that you pose or are suspected of posing a risk of piracy or terrorism or a threat to airline or passenger safety. A true copy of the letters attached here too, all of which is incorporated herein by reference in its entirety. More war crimes by the Obama administration taking reprisals for political beliefs, and the Texas DPS malicious, slanderous, defamatory intelligence bulletin full of hearsay information obtained with an illegal search and seizure. Actually, that's what I'm going to add in. It's aggravated identity theft is what it is. And so anyways, because the Five Eyes foreign enemy buddies in Communist Canada were sharing their smuggling conviction with their Communist buddies here in retaliation because the demandant had the audacity to exercise constitutional rights of exhausting administrative remedies, seeking a redress of grievances, self-determining Texas national status, as evidencing their intent to deprive the demandant's right to pursue happiness by getting compensation for labor. On August 15, 2015, after 6 weeks working there, the demandant was laid off from GKN Aerospace in Montgomery, Alabama, and when laid off, they held a meeting, told the demandant had nothing to do with work performance because they were very happy with the work performance, but their corporate office had ordered it. The head office of GKN Aerospace is in the United Kingdom, one of the foreign enemies, Five Eyes Alliance, sharing their smuggling conviction from Communist Canada. That's the last job the demandant had working in the aerospace industry, evidencing they intend to engage in slander and defamation to make sure the demandant is denied the right to pursue happiness by getting compensation for labor in support of the war crimes agenda against the demandant and the people of the Republic of Texas, in support of the Texas DPS malicious conspiracy with the Montana Highway Patrol and the Obama communist agenda, in retaliation for exercising constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status. In the year 2017, while visiting the demandant's daughter and grandchildren, the daughter asked the demandant to leave because her husband, a prison guard with the Immigration Service at the time, was nervous about losing his security clearance. A true copy of the letter she gave the demandant attached here too is Exhibit 6, all of which is incorporated herein by reference in its entirety, and further evidence that these military police and their bar member handlers intend to slander and defame the demandant, make sure he's denied access to his own children and grandchildren in support of the malicious Texas DPS slander and defamation against him and the people of the Republic of Texas, and in conspiracy with the Montana Highway Patrol in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and seek self-determined Texas national status. The demandant's sons, Nelson and Wilson, are afraid to talk to him for fear of losing their security clearance. More slander and defamation by the malicious Texas DPS and conspiracy with the malicious Montana Highway Patrol and their military police, and conspiracy with their bar member handlers for exercising U.S. constitutionally protected rights to petition the government for a redress of grievance with the Montana Highway Patrol, and exhausted administrative remedies and exercises right to self-determination as a Texas national in retaliation. The resolution of Congress says that because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 3, 1940, at 54 Stat 178, says in the preamble, where it is desirable that the sovereign citizens of our nation be prepared for the responsibilities impressed with the significance of their status in our self-governing republic, whereas 22 million young men and women in the United States each year reach the age of 21 years, and whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. It is affirmed by Harold M. Stevens, Chief Judge of the United States Court of Appeals for the District of Columbia Circuit, in his article in the American Bar Association Journal, Volume 37, Number 4, April 1951, entitled Citizenship, the Real Profession of Every American. If our sovereign citizens are not informed upon such subjects, how can they intelligently participate in the determination of pertinent national policies? Therefore, we, the people, are the government. That is why it's called a republic. During the Obama administration, the communists and the weaponized Federal Bureau of Investigation made war on the republic by using sovereign citizen as a buzzword for persecution and prosecution, and then circulate numerous news releases stating that all sovereign citizens are terrorists, as found in an ABC News article entitled Sovereign Citizen Terrorism Assessment Warns of Rising Threat from Anti-Government Extremists by James Thomas on 30th November 2015, and in a news article on RT.com entitled Sovereign Citizens Seen as Top Terrorist Threat by U.S. Law Enforcement by Brian Blanco on 5th of August 2014, and numerous other articles by stating they intend to murder any sovereign citizen without a trial, without due process of law, by Obama's military police order followers. All of the wrongdoers named herein are operating in support of Obama and his communist buddies to overthrow a republic, which is treason. Obama's weaponized Federal Bureau of Investigation even published a sovereign citizen quick reference in support with the Joint Terrorism Task Force, a true copy of which is attached here too as Exhibit 19, all of which is incorporated herein by reference in its entirety. In an effort to exhaust administrative remedies and exercise the Article 1 Amendment right to petition the government for redress of grievance started in the year 2007, over a period of about 10 years, the demandants sent out thousands of notice and demands, almost all of them by registered mail, and the first paragraph of all of them says, "I accept your oath of office." And in all fairness, most of the government officials with notice and demands were sent to were just honest, hard-working officials. A judge in Johnson County, Texas, returned a copy of his oath of office and surety bond, and a county sheriff in New York returned an insurance claim form. The demandant would never do anything to cause injury to such honorable public servants because we need such people to keep the peace. As is said in the notice and demand, that the demandant understands his duty to come to their aid when called upon, as found in Posse Comitatus, the power or force of the county, the entire population of a county above the age of 15, which the sheriff may summon to his assistance in certain cases to aid him in keeping the peace and pursuing and arresting felons, etc., and will be there for them any time, any place. On the other hand, the Pennsylvania Assistant Attorney General returned a malicious letter saying that if the demandant drives in Pennsylvania without a driver's license, they would arrest the demandant and put the demandant in jail. The demandant took their letter with a copy of a notice of demand, made a 2-page criminal complaint, sent it to the U.S. Attorney in Harrisburg, Pennsylvania, and 2 weeks later got a letter saying, "We've referred this matter to the FBI." And 6 months later, the Pennsylvania Attorney General's website showed they had an acting Attorney General, which means the previous Attorney General left office before his term was up. In 2021, the demandant converted silver to land. The county of Montague, under the direction of the Texas Comptroller, proceeded to enslave the demandant with their minor estate, tax notices, tax liens, and threat letters. The demandant served by registered mail a Catherine Phillips notice and demand, demanding that they produce a bona fide contract, and they never responded to it in any way. The county of Montague filed a malicious tax suit in the 97th District Court. The demandant filed 78 criminal complaints into the case and sent them to the weaponized Federal Bureau of Investigation, and the weaponized United States Attorney and the weaponized Department of Justice ignored them in retaliation for exercising U.S. constitutionally protected right to seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. The demandant filed a petition for writ of mandamus for the Second Court of Appeals in order to order the lower court to prove standing and jurisdiction, and the malicious clerk of the Second Court of Appeals refused to accept it because the demandant is a vexatious litigant, and they're sure to send their they were sure to send their letters refusing the petition to the 97th District Court and the liars to make sure and notify them that the demandant could be denied due process of law with impunity, and get them into conspiracy as accomplices in retaliation for exercising U.S. constitutionally rights to protect, seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. The demandant brought the case to a Republic of Texas common law jury, which issued an affidavit of finding of facts. The bought and paid for a clerk masquerading as a judge in the 97th District Court subjected the demandant to their star chamber with their forced legal counsel, and they maliciously assaulted the demandant with the minor estate to justify the theft of his land, and enslaved the demandant for their Vatican handlers. And they were in the process of selling the land when, on the day of the sale, the demandant set off their extortion with their Federal Reserve note, commercial paper, fake money that are only for use in the District of Columbia under the Gold Reserve Act of 1934. The demandant has never in his life breached the peace, but the weaponized Federal Bureau of Investigation military police under the direction of Yarborough refused to investigate the felonies, and the weaponized United States Attorney under the direction of Simonton refused to prosecute the felonies that the County of Montague engaged in to support their weaponized Department of Justice and their communist handlers to implement the first plank of the Communist Manifesto on abolition of private property rights in retaliation for exercising U.S. constitutional rights to seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. The demandant filed a lawsuit in the Fort Worth Federal Court, and Hal R. Ray and Reed O'Connor maliciously issued the findings, conclusions, and recommendations of the magistrate judge, which fails to be the required findings of fact and conclusions of law, which means it has nothing to do with facts or law, evidencing they intend to be accomplices to the demandant, to assault the demandant with the minor estate in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievance, exhaust administrative remedies, and to self-determine Texas national status. The demandant filed 78 criminal complaints into the federal lawsuit, and they maliciously got unfiled, evidencing the case was prejudged in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status. One of the wrongdoers in the lawsuit was Stephen McCraw, director of the Texas Department of Public Safety, because of the intelligence bulletin. The demandant filed document 104, notice of objection to the magistrate judge's findings, conclusions, and recommendations, and motion to reconsider. The demandant filed a notice of appeal. It's in the U.S. Court of Appeals for the Fifth Circuit. They just got the answer today. The demandant filed document 108, notice of constitutional challenge, because they're obviously assaulting the demandant with the minor estate. The demandant filed document 112, mandatory judicial notice of 12 presumptions. To defeat the presumptions they like to take about trusts for their Vatican handlers. In every document filed into the case, the demandant put himself down as a living man on the land of Texas, but because they're obviously using trust law, the demandant filed document 113, affidavit of life, filed 30th May 2025 to defeat the presumptions that the demandant is lost at sea, absence of 7 years, presumption of death, that they maliciously take for their Vatican handlers so they can assault people with their trust law under Roman law because a trust is property and has no rights, because the demandant has lots of first-hand knowledge of how they love to use trust law to enslave people for personal profit for their Vatican handlers in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status.
Breathe.
Yeah, really. I'll bet everybody can hear it good.
Loud and clear. No, I get it. I'm with you on that elevation of tone. So the state attorney for Pennsylvania went on an extended holiday after you submitted your paperwork.
That wasn't extended. He got removed. I don't know if it was because of what I did, but it's amazing how many times I do something like that and something like that happens.
Yeah, he was worth removing. Good job.
So the demandant filed document 114, a notice of void judgment. Marshall Thomas and Leah Simonton maliciously have a problem with some of the things the demandant said in the federal lawsuit, as evidenced by complaint number 1883286 filed with the Tarrant County District Attorney, and it's not even signed by Simonton or Thomas, almost a year after the alleged incident. all of which the court said nothing about it, and the demandant was trying to get a redress of grievances, which is a right under Article 1 and Amendment, because the thieves engaged in the theft of the demandant's land. And the case is not over, but it's in the U.S. Court of Appeals for the Fifth Circuit, in which the demandant tells them he wants the minor estate dissolved and liquidated, and the demandant fails to care what they do with the fake money. They can put the fake money up their rectal orifice. The minor estate is a complete fraud and a badge of slavery, and the demandant wants nothing to do with it, wants it dissolved and liquidated. The demandant has also filed a Rule 11 petition for writ of certiorari with the U.S. Supreme Court, challenging the constitutionality of the 1871 Municipal Corporation, the minor estate, and the National Bar Foundation, because Article 1 and Amendment requires that Congress shall make no law respecting an establishment of religion. And it's all coming from the pimp, or the Pope, I meant. Nah, the pimp. The demandant finds it interesting that Thomason and Simonton filed this malicious criminal complaint at the same time that Captain Michael Lugo was maliciously complaining about the Republic of Texas common law court judgment, like they're piling on, trying to get in on the action in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exercise administrative remedies, and self-determined Texas national status. Furthermore, Thomasons and Simonton are maliciously trying to interfere with the right to appeal this matter, which is another war crime, and Simonton was the former U.S. attorney and deemed to know the law. Therefore, it's deliberate, calculated, and malicious. And she is knowingly intentional participant in all the crimes described herein and cannot claim any plausible deniability or good faith. I think this part we've gone through. As a matter of fact, I'm sure of it. The arrest by the pigs in New Mexico. I did a police report on that too, and I haven't gotten the results yet back. I only did it a couple days ago, so it'll be interesting to see what the results are. I'm making up summonses. Sorry?
Are you going to do a Freedom of Information Act on that arrest too?
That's what a police report is.
Okay.
Yeah, I know I've gone through some of this.
There's a term I found out about, that all the meta data that they collect from Five Eyes and going through all these scans is called metadata.
Yeah, I'm not surprised. What are you saying? They're collecting data on us right now?
I think so.
Yeah, good.
Eric Snowden confirmed it again.
Yeah, no doubt. Well, Snowden said that your phone can watch you whether it's on or off. Can listen to the conversation.
And scan your email, apparently, now.
Yeah. Let's see here.
If you have a Gmail account only, apparently.
Oh, well, Gmail account is the worst, and I've got several of them. Is there anything else that we want to go through? I'm just trying to think. I mean, I think we've pretty well gone through all of this now, or all of it that, well, let's see here. Yeah, this stuff we went through last week. I bet you I get Phil Soros fired. Or he'll resign. He definitely... Oh, get a load of this. Well, I already went through this, eh? On 20th September, the demandant's wife called from Vancouver, wanted to know what was happening because it was on Facebook that the demandant was in jail. And the demandant explained to her what had happened and evidencing the malicious defamation, slander, terrorism, war crimes by the Texas DPS, the Montana Highway Patrol, military police, and the Joint Terrorism Task Force and their military police and their bar member handlers named herein in retaliation for the defendants exercising constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, self-determine Texas national status, and conduct a common law court. The defendant asked his daughter in Arizona what they were doing for Christmas, and on 7th of October she answered the test, and she said she was not comfortable having the defendant in her home, but could meet for dinner somewhere. You know.
Well, you're lucky. At least
I
your
told
daughter right.
I told my wife that I'm thinking about disinheriting my kids. You know, I can make a will and say I disinherit my kids. I don't want them getting shit.
I bet you that was not a very good conversation.
Well, I think she understood. My wife is, anyways.
Hard one, never the hard conversation, nevertheless. I know, I have them.
Yeah. One thing, the rights protected by war crimes by the Geneva Convention relative to the protection of civilians in a time of war of 1949 cannot be renounced, waived, or given up. The Federal Bureau of Investigation agent Casey Brashear brags about he maliciously got Bonnie Strait, previously Brown Thomas, into Texas jail, and has bragged that he intends to shut down the Republic of Texas. Bonnie Strait was chief counsel for the Republic of Texas for 4 years, from 2018 through 2022, and is entitled to a lifetime diplomatic immunity under international law as an executive officer for the Republic of Texas. And they're currently doing to Bonnie what the communists always do to their political dissidents, put them into mental institutions to perform forced medical experiments on her by foreign immigrant Dr. This rug pilot, East Indian doctor, is maliciously subjecting Bonnie to a forced medical experiment with the pharmaceutical called Abilify, more war crimes against the people of the Republic of Texas. Furthermore, Title I, U.S. Code Section 1 says that someone who is incompetent is insane. The words insane and insane person includes and person non compos mentis, that's incompetent, which means that just because Bonnie Strait might not be 100% correct in her arguments in her case, and because the Pope's fake judge Bosworth in the case wants to sit there and play stupid and presume Bonnie Strait is dead or lost at sea and impose the Pope's Roman trust law on Bonnie Strait, she is maliciously declared insane and committed to a mental institutions for forced medical experiment war crimes.
Have you been able to get in touch with her?
Yeah, she called me earlier today. I was talking to her. She's back. Actually, they moved her. She's not in that mental institution anymore, but where she's at is probably worse. She's in basically segregation in Johnson County now. The Pope now owns and operates the 1871 municipal corporation with the bankruptcy emergency. Okay, it's established fact that the United States federal government has been dissolved by the Emergency Banking Act. Since March 9th, 1933, notice the date? March 9th, 1933. Since March 9th, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities. Okay, so it's bankrupt. Because martial law rule is the law of emergency and necessity. And that's ex parte Milligan, which makes it satanic, and Satanists are using the Pope's Roman law, Capitis Diminutio, to populate the prisons by selling people like Ken Ouimet, the defendant, and Bonnie Strait into slavery. And because the administrative proceedings under the Pope's Roman canon law of trusts, there are more people in prison in America as a percentage of the population than there are in communist China, or were in the Soviet Union, or the worst dictatorship in history. And if there were Christians here, the bar members doing it would get their necks stretched. Yeah, all these fucking Satanists out here that think they're fucking Christians, the judgments of God are going to come upon them, I'm telling you. They're going to be fucking ugly. It's going to be ugly for all of us. And the Innocence Project estimates that 60% of the prisoners are innocent, but it's such good business for the Vatican and their Roman law so-called courts, which is one of the grievances of the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coast, burned our town, destroyed the lives of our people, all of which has been planned and orchestrated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. And the Pope now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman Achaia military staff right here, that is carried in battle by all Roman commands and planted on all conquered nations, that's sitting on the right side of the speaker's podium in the U.S. House of Representatives, right here, and 2 Roman fascia, a bundle of rods bound into a weapon symbolized under the rule of a single man, that are on the wall of each side of the speaker's podium in the U.S. House of Representatives, which is also why Nancy Pelosi, when Speaker of the U.S. House of Representatives, told the members, we can't read this bill until after we pass it, because she was taking instructions from her Vatican handlers, all of which is evidencing the fact that the 1871 corporation, 16 Stat 419, currently operating in the District of Columbia, is a Vatican-dependent city-state, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities in Vatican City, state, and criminal matters that talks about concurrent jurisdiction in other papal states like the District of Columbia and the City of London. When the same matters are prosecuted in other states, the provisions enforced in Vatican City, state on concurrent jurisdiction shall apply. Apostolic letter issued motu proprio, entered into force 1st September 2013. Which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Vatican's Pope Francis came and addressed his owned and operated Congress on 24 September 2015, and the Pope's owned and operated Federal Bureau of Investigation Joint Terrorism Task Force are assaulting the defendant and the people of the Republic of Texas with their Roman fiction of law minor estate, Sestike Usufruct, with the Pope's Sestike v. Act of 1666, which was brought into the United States with the Code of Law for the District of Columbia in 1901, an act to establish a code of law for the District of Columbia, the legal estate to be the Sestike Use, 31 Stat 1432, now codified at 31 CFR 363.6, and the Pope's necromancy Sestike Use, which is usufruct, and people are presumed dead at Chapter 3, absence of 7 years, where it says presumption of death. He shall be presumed to be dead in any case where his death shall come in question. And the Pope's Uniform Commercial Code. But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights and duties and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until the evidence is introduced as sorts of finding of its non-existence. All of which is unconstitutional because Article 1 of an amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In 2024, we in the Republic of Texas wanted to peacefully help other Republic of Texas people currently in Texas jails, and we held some common law courts. We got a known case that is upheld by the 14th District Court in Dallas, case 95-07735 on 19 September 1995, called Ayabello Corp. WFAA-TV versus Johnny Johnson and Lakeview Developers, to use it as a template. We organized a common law court, got seals, followed it in every detail, for about 6 cases, one of them for Ken Ouimet that was filed into him case, and one of them for the defendant that was filed into this case. 0881 to get some constructive feedback on whether we need to make corrections because 30 years had passed. Our sole interest was to help people, especially people who are associated with the Republic of Texas. We needed to be recognized by the state of Texas military government to help people in Texas jails. We, the people of the Republic of Texas, wanted nothing but a peaceful, friendly relationship with the military government of the state of Texas. On 30th of June, 2025, the demand and served Joseph R. Rothrock, Special Agent in charge of the Federal Bureau of Investigation, Dallas Field Office by registered mail, and notice and demand. And the first paragraph says, I accept your oath of office. But the demandant should know better than to think Rothrock would, of the weaponized Federal Bureau of Investigation, would honor their oath of office. It appears that Casey Brashear and his military police are going to get their desire to eliminate the Republic of Texas because the demandant has resigned his Senate seat, and all of this rest of them are running scared, terrorized because of Brashear's malicious prosecutions. So Brashear can be proud that he's such a good terrorist, and have perjured their oaths to support the supreme law of the land and violated the supreme law of the land in support of their District of Columbia military dictatorship. The people of the Republic of Texas are refraining from engaging in constitutionally protected activities after being terrorized by Brashear and his military police and their bar member handlers. Casey Brashear and his weaponized Federal Bureau of Investigation military police buddies, Andrea Brandt, Captain M. Lugo, are the terrorists terrorizing the people of the Republic of Texas with their malicious prosecutions and a malicious conspiracy with the Texas DPS and the Montana Highway Patrol military police dictatorship. And then when we turn up dead, they get to pillage the fake money from the Treasury Direct account under the Hague Convention concerning the International Administration of the Estates of Deceased Persons, concluded 2nd of October 1973. And the demandant is not suicidal, but if the demandant does turn up dead, this is deathbed testimony, or the demandant will be subjected to the District of Columbia military prisons with false arrest, kidnapping, false imprisonment, and just like what has already happened as described herein with their warrants that failed to be authentic and their Roman canon law so-called courts. Therefore, whether they enslave the demandant or kill him resisting their slavery, either way it's a win-win scenario for these military police and their bar member handlers, violating our right to engage in constitutionally protected activity under color of law, and conspiracy to threaten, coerce, injure, intimidate us in the free exercise of our right to engage in constitutionally protected activity under color of law in support of British intelligence George Soros and his communist Chinese handlers. All this is evidence that there's no justice in Texas military so-called courts because the bought and paid for clerks masquerading as judges like Stephen Jones, Elizabeth Beach, Hal R. Ray, Reed O'Connor, and Patricia Coleman Byers want to sit there and play stupid and assault people standing in front of them and pretend they're the minor estate Sestike usufruct created by the Pope's Sestike V Act of 1666 and brought into the United States with the Code of Law for the District of Columbia in 1901, an act to establish the Code of Law for the District of Columbia, the legal estate to be the Sestike use, now codified at 31 CFR 363.6, and the Pope's necromancy Sestike use, people are presumed dead, at Chapter 3, absence of 7 years, presumption of death, and so they can assault them with the minor estate 31 363.6 and trust law, which is part of the Pope's Roman canon law, to engage in the commercial transaction under the Pope's Uniform Commercial Code. But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their personal privilege. Rather, they assume the rights and duties and privileges of the artificial entity or association over which they are agents or officers, and they are bound by its obligations. To justify pillaging fake money from the Treasury Direct account because they get fees for personal profit or gain under the Code of Law for the District of Columbia, now called United States Code. They get a fee for drawing a complaint at 31 Stat 1366 for issuing a commitment. That's a fucking prison sentence, folks, is a commitment. Drawing a bond, the fucking whore gets a commission off of that. Issuing a arrest warrant, they get a fucking commission off of that. Which is unconstitutional because Article 1 of the amendment requires Congress shall make no law respecting an establishment of religion. Right now, we have a government that completely ignores the Constitution. Fuck the Constitution. It's a fucking rag. It's a piece of fucking shit. Anyways, I think I'm done.
My dogs are going off because of DoorDash, or I was going to reply with, well, there's a document in Canada that's exactly the same thing, so I understand. And I'm done too. But that's loaded up. You didn't miss too much.
I guess we're about done. Anyways, do we have anything else we want to cover? Has anybody got any questions?
Glenn, what is this? I got in about probably 1/4 of the way through after you started. What is this? What are you filing? What's this for?
This was a lawsuit that I just filed, actually.
Okay.
I'm preparing summonses for it right now. I'm thinking about sending Trump a copy because he might want to know about it. But anyways, I'm going to file a amended petition, so I probably wait till after I do the amended petition. There's a bunch of changes I want to make to it. I want to add a few people into it, and I wanted to get it filed. Anyways, I guess we'll see.
Yeah, they're not doing much these days. I've filed in federal court. I've been through the state court. I'm about to get evicted, and I mean, I've surrendered all my stuff, my birth certificates to everybody, and amnesty oaths and everything, and my trust, and they just don't care. They just don't care. State and honor.
Yeah. I don't know what to say. What I'm doing.
Oh no, there's nothing to say. I mean, it's just. I mean, as you're reading, it's getting me all fired up too, and it's just sad. I mean, like, there's no way out. Like, I don't see a way out.
Well,
of this.
In the Bible, in Matthew, it says that if they won't hear your testimony, shake the dust of the earth, mop your feet against them. And so I have their names. And every time when I take a shower, I read off their names and I say, in the name of Jesus Christ, I shake the dust of the earth, I'm off my feet against, and I name their name. And I put it in God's hands. That's all you can do at this point. Let God take care of it. And one thing is guaranteed. On Judgment Day, I'm going to be saying to that motherfucker, why the fuck didn't you do something about this? That son of a bitch. Don't get me going. Don't get me going. You're going to get me going now.
Well, there's something I like the add-on about the personal aspect of it. That's very brave, very raw, and that's something that I have not done with my story, as you told me to do years back, is write my story. I never really put the personal aspect in it, but that gets it all on the record, and that gets it all, put on so that others can read your story and be aware of how the shit went down on your perspective. So I like that. I like that change you made. Very, very personable. I like it. Thank you for doing it.
Yeah, well, they just ignore the Constitution. It's the Vatican.
And the Charter.
Sorry?
And the Charter of Rights up here. They don't honor anything.
Yeah, it's the Vatican. That's why I say it's the Vatican. They're Satanists. It's the Vatican. They don't give a shit. It's probably, I guess we'll see. I think that, I guess we'll see. I hope the military steps in. That's all I can say. I think that's what it's going to take.
That's what they're asking for. There's a big, not protest, but The farmers are all going on the highway tomorrow to protest all this, so people are waking up and starting to speak up here, and that's a good thing. It took a lot to get the farmers going. You know, the truckers 3 years ago were torqued up, and now the farmers are going. So everybody's seeing how it's being, you know, they're saying one thing and doing another. So people are just tired of it. But you've got it on the record. And I think that Judgment Day is going to come sooner than we think for these Satanists because, you know, they don't win in the end. I want to tell you a story. Back in the First World War, the 91st Brigade apparently recited Psalms 91, verse 91, every day, which talked about keeping the evil away from their combat. And it was the only tent, apparently, that didn't get bombed in the First World War. And the only thing that brigade can account it to was praying and starting off their day with that prayer. So,
An interesting story.
very. We have to keep these, well, I don't want to say the words, but we have to keep these horrible beings at bay with our prayer and demand they stay away from our family and our loved ones.
Yeah,
So,
well, you know, that didn't help much, quite frankly. I mean, I consider myself Christian, and I certainly treat people right, make sure that I do. Anyways, that didn't make a lot of difference with these fucking pigs in New Mexico. And you know, I had this feeling come over me that this is going to be the best thing that ever happened. But you know, cash talks and bullshit walks. You know.
yeah, and this is number 6 time you've been there, so this is going to be impactful. I know it.
Well, it's yeah. I'm gonna continue to pursue it to the Supreme Court, but you know, I've been there 5 times and I know what they did the last 5 times, so I'm kind of wondering if that's what's going to happen this time too. But anyway, so I guess we'll see.
We will.
But I got it. They're going to send that. I sent in that Rule 11 petition, and so now that the case has been decided, they're probably going to send it back, and so, but I'll have to redo it completely. I was thinking about that because I got to look at the rules. Um, I'll have to make a few changes. The question will be the attachments, whether I can keep the same attachments and keep them in the same order. If I can keep them in the same order, then that'll cut down the amount of work I have to do. But I guess we'll see. At any rate, I suppose that's about it. I appreciate everybody watching, and what I'm going to do is I'm going to upload the Word file from this to the group. Matter of fact, I'll do that right now while we're talking here. That way it'll be, I won't have to, nobody will have to bug me about it. Oops. First of all, I'm going to upload that.
The one Mary wanted.
Notice of objection to District of Columbia electronic filing.
Uh-huh. Yeah, please.
And I'll upload the Word file. Yeah. And I'll upload the, what else? I can upload the Supreme Court petition.
Yes, please.
I wanted to make sure I got all files. There's a affidavit. They wanted me to fill out this informal papyrus thing. So I give them a 1-page affidavit. So you'll like it. And then there's a petition for writ of certiorari. There's the questions for review. There's the table of authorities and the table of contents. And so all of that stuff is uploaded right now. Anything else while we're here? While I'm thinking about it.
Let's see. They comply with the No Paper Act or something like that. Is that the reason for all this electronic filing? What's your take on it? Or what was the reason they gave you for them wanting it in this
They don't give you a
format?
reason. They don't give you a reason. They just tell you have to do it. And I tell them, no problem. I'll be glad to do it when you provide your statutory and delegated authority and a search warrant and an order, a lawful order. I'll show you this. I'll show you this. This goes back to the, matter of fact, I think I closed it. I did. Okay, let me find it. Yeah. I'll show you this. This is important because this is how they do it. That's another reason I kind of ignore it. Anyways, here it is. So this is the document. Okay, this is what they gave me that told me that I had to. But look how official this is, eh? Look how official. It goes down and has a list of things I have to do, and it's not even signed. It's not even signed. It's not issued by the court or by the judge. It's just a bunch of printed crap. And so I basically, I respond. And so you got my response, but this is the kind of crap that they do. Anyway,
So who are you going to address it to? Just the court clerk?
Yeah, I'll file it. And I'll have an affidavit of service. Let me see here.
Yeah, I'm finding nothing is ever signed.
No, yeah, Glenn. I mean, they sold my house. I mean, everything, all of the documents I went through and did like a forensic audit of my own on them. No, I mean, no, there were no clerk signatures, no court seals. It was just random employees. I got FOIAs on everybody's oath, and they're like 24-year-old employees signing off on, and they probably didn't even sign them to sell my house. And then forged sheriff's bullshit, sheriff sales crap, wrong plaintiffs names on all kinds of documents. It's like it's just, I don't even have a word for it. You know what I mean? Like, I don't have a word for it.
If you go back in my page, there's a video I uploaded, a link to a YouTube video. Where is it? Yeah, right here. I don't know how far back it is, but it's called Secret Financials Underlying Our Justice System with Todd Duell. You ought to watch that video because he can help you with mortgages. He's a pretty sharp guy. He's really sharp guy, and I'm starting to use some of his stuff. He goes through and he's got some really interesting stuff. I'll tell you. I would highly recommend. You might be able to get your house back. What
page that's on?
I don't know what page it's on. It's on the 15th of November when I put the link up there. So, and today is the 21st. So it's, you have to go back to the 15th of November and it'll be there.
I appreciate you.
And I would highly recommend you watch that video. And those notes, I've got notes that I uploaded. Those notes are related to that video. And that's real good notes, let me tell you. But I would highly recommend you watch that video. And
I've seen that video like 3 times, and I have taken notes. And I have no problem. I mean, he's right. He's right on, spot on. But the problem is, like, I live in a fairly large city, and my county is. They have already retaliated against me. If I walk in there asking for bonds and whatnot, they'll be throwing me in jail, And I'm almost 60 years old.
He gives you a bunch of IRS forms that you can file. And what you do is you file forms with IRS complaining about identity theft. The IRS will go look into it. And you can drag their ass into tax court. And so when IRS, the IRS, there's tax evasion. Okay. So, I understand that they're a bunch of thieves. And so, I wouldn't fucking tell them shit. I'd go and take it to the IRS, let the IRS go down there and talk to them. Anyways.
Yeah, go on, read publication 5251. That give you the guidelines on the 3949A 211, 13909, and 14039 that need to be filed. But also remember, Rule 13 tell you that you have to file a counterclaim. So if they bring a claim against you, you file a counterclaim in federal court and do a notice of removal under 28 U.S.C. 1446. Do a notice of removal into federal court and file a federal lawsuit against them. Only way that you're going to actually have to bring evidence in is you're going to actually do, it's called a subpoena duce and tecum. You do a subpoena duce and tecum and ask them for all the records and full accounting under 9 USC 210. And they'll have to bring in full accounting. And you have to do that by actually, with the subpoena duce and tecum. You have to do you have to do a complaint. You have to do what else it is? You have to have a complaint. You can actually do either a motion to compel evidence, and you need to actually have the one that starts with an S, a subpoena. You can do a subpoena and subpoena the record, and that's how you actually get them to actually bring everything that you asking on the record, and it's on a penalty and perjury. Now you.
That's all interesting. What if you watch that video? He says that they get rid of all that evidence as quick as possible, and so but you can find out, like what I was thinking is get a forensic accountant, because you can find out what the transactions have been going through the Treasury Direct account, and so you can still recover that information. They may not have it. And if they don't have it, if they get rid of it, then they don't keep. I don't know. Certainly, I'm not saying don't do it, but what I was planning on doing is getting a forensic accountant to go through there and check it out. But anyways, so this notice of objection to the electronic filing, this is page 2 and this is page 3. That's all it is. It's 3 pages. It's a certificate of service and a two-page notice of objection. It's really short and sweet. And so let me just make sure I uploaded it to the group. I did. So it's uploaded, and so you have access to it. And it's a networking thing. I don't know everything, and so I'm open to any ideas anybody might have. Just like this one guy was just saying about this subpoena ducis tecum, and so maybe we can somebody can specialize in this. This is something I'm just learning about, and so but I'm going to bring it up. That's why I'm going to do an amended war crimes complaint, because I'm going to bring that up because that's what they're doing, is they're assaulting me with that minor estate, and it's aggravated identity theft. That's what it is. Anyways, I guess that's about it for this week. We'll be back.
You can get them. You can get them for treason under actually under the war crimes that they committed under 15 USC 1 and 2. So anything that's over $10,000, they supposed to report it. So you can do an 8300 form with the IRS and have them to audit their accounts. Because all this stuff deal with accounting in it. Bring them into tax court, find out how much the accountant is and how much taxes that they owe that they haven't actually paid to the IRS, and start making it all a tax matter. Or either file a 1099s on them and report the accountant to where they can get audited.
Right.
That's one of the best strategies to do.
That's actually what that guy says, is to file a 211, which is a whistleblower form, and it starts with the 211, IRS form 211, and it's a whistleblower form.
Yeah.
Anyways.
Yeah, that's on a publication 5251. It's 5 pages. Go read publication 5251. It tell you how to fill out everything.
Okay, maybe I'll write that down.
Thank you, Private Lucky.
Publication 5251.
I got it. Yeah.
Right.
So other than that, we'll see you guys same time, same place, same channel next week.
Don't be late.
All right. Take care. Thanks for watching. Thanks for all your input. And, it's a networking thing. I don't know everything. I'm willing to get your ideas. I'm going to check out this publication 5251. All right. You guys take care. We'll see you next week.
Please
Take care,
post
Glenn.
that on the wall, please, Glenn. Thank you very much.
He did.
I posted that whistleblower complaint 211 and publication 5251. Sounds like
Make sure you file the taxes so they can get audited when you do it, though. Because when you file the taxes, when you do it, they're gonna get audited for sure.
All right.
Also, a form 56, you can actually appoint the judge as a fiduciary trustee under UCC 3-311, which tell you that for full satisfaction of the claim or whatever account. And once you actually appoint them as trustee, you can appoint the sheriff, because the sheriff actually is the trustee of that account too. All of them getting paid through it. Once they become trustee, they become liable, and you can actually hold them accountable to that.
All right. See you guys next week.
All right.
I never understood that appointing a judge on the 56, because